I was standing at my kitchen window watching a construction crew erect what looked like a small building on my wooded property when I realized the HOA had finally lost their minds. The property in question was a 4-acre parcel of forest land in Asheville, North Carolina, that I'd purchased 3 years ago specifically because it was outside the HOA boundaries. I'd checked the property lines 6 times before buying, hired a surveyor, and even had my lawyer verify that this land was completely separate from the residential development where my actual house sat. My name is Marcus Abbott, and I'd worked in construction management for 15 years before starting my own contracting business. I knew property law, I knew building codes, and I definitely knew when someone was illegally building on land they didn't own. The structure going up was roughly 12 by 16 feet, with walls that looked like they were being framed for insulation. Through my binoculars, I could see they were even running electrical conduit. I grabbed my truck keys and drove the half-mile down the road to the access point of my forest property. Sure enough, there was a dumpster in the clearing, 2 trucks I didn't recognize, and 4 workers actively constructing what appeared to be a warming hut. One of them was nailing down roof shingles while another was installing a window frame. "Hey," I called out, walking up to the site. "Who authorized this construction?" A middle-aged man in a hard hat looked up from his circular saw. "You'll have to talk to the HOA. We're just the contractors." "Got a work order right here." He gestured to a clipboard hanging from a nearby tree. I walked over and grabbed the clipboard. The work order was from Maplewood Hills HOA, signed by one Brenda Overstreet, HOA president. The description read, "Construct warming hut for community winter activities." Location: Community Forest Parcel, Lot 847. "This isn't Lot 847, I said, my voice level but firm. "This is private property, my property. Lot 201, which isn't even part of the HOA. The contractor's face went pale. "Sir, we were given GPS coordinates and everything." "The HOA president walked the site with us 2 weeks ago." "Then the HOA president trespassed on my property 2 weeks ago and has now hired you to build an illegal structure. I'm going to need you to stop work immediately." Another worker, younger, piped up, "We can't just stop. We've got a contract." "Your contract is void because it's for work on property the HOA doesn't own. If you continue, you're participating in the trespass, and I'll have to call the sheriff." The head contractor pulled out his phone and stepped away. I could hear him having a heated conversation, presumably with someone from the HOA. After about 5 minutes, he came back. "Madam says she has documentation proving this is HOA common land. She's on her way over now." I nodded. "Good, I'll wait. But your crew stops working until this is resolved." The contractors, looking uncomfortable, set down their tools and gathered near their trucks. I walked around the structure, taking photos with my phone from every angle. The foundation was already poured, the framing was nearly complete, and they'd even started on the roofing. This wasn't a simple mistake or a small encroachment. This was a full-scale construction project that had clearly been planned for weeks. 20 minutes later, a white BMW SUV came bouncing up the dirt access road. Out stepped Brenda Overstreet, a woman I recognized from HOA meetings I'd been forced to attend regarding my actual residence. She was in her early 50s, with short blonde hair styled in that specific way that seemed universal among HOA presidents, wearing a cream-colored pantsuit that was entirely inappropriate for a construction site. "Mr. Abbott," she said, her voice dripping with false sweetness. "I understand there's been some confusion." "No confusion on my end. You're building on my property without permission." She pulled a folder from her oversized purse. "Actually, according to our records, This parcel was designated as common land when the development was established. It's meant for community use. Show me the deed. I have a map right here. She unfolded a document that showed the Maplewood Hills development with various parcels marked in different colors. That's a map, not a deed. I have the deed to this property, recorded with Henderson County. Lot 201, 4 acres, purchased by me 3 years ago from Timothy Richardson, who inherited it from his parents. It has never at any point been part of the Maplewood Hills development. Brenda's smile tightened. I think you're mistaken. We did our research before beginning this project. This land has always been intended for community use. Then you did bad research. I want your contractors off my land. Now. These men have a job to do, Mr. Abbott. The community voted on this warming hut. It's for the children, for winter activities, for bringing our neighborhood together. Then build it on land the HOA actually owns. Not my land. She crossed her arms. I'm not stopping this project based on your unsubstantiated claims. If you truly believe this is your property, you can take it up with the HOA board at our next meeting. I pulled out my phone. Okay. Then I'm calling the Henderson County Sheriff's Office to report a trespass in progress. You're being ridiculous, Brenda said, but I could see a flicker of uncertainty in her eyes. I dialed the non-emergency number. Yes, hi. I need to report an illegal construction project on my property. The HOA is refusing to stop work despite being informed they're trespassing. The dispatcher told me a deputy would be out within the hour. I thanked her and hung up. You're making a big mistake, Brenda said. The HOA has significant resources. We can make your life very difficult. I'm sure you can, but you're still trespassing. The contractors were packing up their tools without being told. The head contractor approached Brenda. Madam, we're going to clear out until this gets resolved. We're not getting caught in the middle of a property dispute. You can't just leave, Brenda protested. Actually, we can. Our contract specifies that the client guarantees clear title and permission to build. If that's in dispute, we're not liable for stopping work. You'll hear from our lawyer about the deposit situation. The crew loaded their trucks and left within 15 minutes. Brenda and I stood in the clearing, neither of us speaking, waiting for the sheriff's deputy. The partially constructed warming hut sat between us like evidence at a crime scene. Deputy Williams arrived 45 minutes later in a Henderson County Sheriff's cruiser. He was in his 30s, professional, and took his time listening to both sides of the story. I showed him the deed I'd pulled up on my phone from the county records website. Brenda showed him her map. Madam, Deputy Williams said carefully, this map doesn't override a recorded deed. If Mr. Abbott's deed shows he owns this property, then this is his land. But the HOA has always maintained trails through here, Brenda argued. That establishes community use. Walking trails don't establish ownership, the deputy replied. That's not how property law works. If Mr. Abbott purchased this land legally, and I can verify his deed matches county records, then you're trespassing by building here. Deputy Williams called into the county office and confirmed my deed on record. He then turned to Brenda with a more serious expression. Mrs. Overstreet, I'm going to have to ask you to leave the property. Any further construction without Mr. Abbott's permission would constitute criminal trespass. Do you understand? Brenda's face had gone red. This is absurd. I'm the HOA president. I have responsibilities to the community. You have a responsibility not to break the law, Deputy Williams said. Please leave the property now. After Brenda drove away, tires spinning in the dirt, Deputy Williams turned to me. You'll want to post no trespassing signs, clear ones, and probably get a lawyer if you're planning any action against the HOA. I'm planning action, I confirmed. He nodded. Document everything. Take photos, keep records. You've got a clear case of trespass, possibly construction without permits depending on whether they filed with the county. Good luck." After he left, I spent 2 hours walking my property line, marking it clearly with orange surveyor's tape every 20 feet. I took detailed photos and videos of the warming hut from every angle, including close-ups of the foundation, framing, and materials. I documented everything with timestamps. When I got home that evening, there were 3 messages on my answering machine, all from different HOA board members, all with the same basic message. I was being unreasonable. The warming hut was for the community's benefit, and I should reconsider my position. The third message, from a man named Gerald who served as HOA treasurer, was more threatening in tone, suggesting that my obstinance would be remembered when it came time to approve any requests I might make regarding my actual HOA-governed residence. I called my lawyer first thing the next morning. Patricia Chambers had handled my land purchase and knew the property history inside and out. "They did what?" she said after I explained the situation. "Built a structure on my land. Got about 70% done before I caught them." "That's bold even for an HOA. Email me all your documentation. Photos, videos, the work order if you got pictures of it, everything. I'll draft a cease and desist letter and a demand for compensation." "Compensation? Marcus, they trespassed on your land and erected an unpermitted structure. At minimum, you're owed the cost of demolition and restoration, possibly more depending on whether you want to pursue damages. What kind of timeline are we looking at? I'll have the letter out by end of day tomorrow. They'll have 10 days to respond. After that, we can discuss next steps." I spent the next morning at the Henderson County Planning and Zoning Office. As I suspected, no building permit had been issued for any construction on Lot 201. The clerk, a helpful woman named Susan, checked thoroughly. "There's no permit for that lot at all," she confirmed. "When was this construction started?" "They've been working for at least a week, maybe 2, she winced. "That's a violation of county code. Construction without permits can result in fines of up to $500 per day, plus mandatory removal of the unpermitted structure." "Who enforces that?" "We do, but we need a formal complaint. I can get you the paperwork." I filed the complaint before I left. Susan said an inspector would visit the site within 3 business days, and that the property owner of record, which was the HOA according to their work order, would be notified of the violation. That afternoon, I drove out to my property again to post no trespassing signs. I put up 8 of them around the perimeter, bright orange and clearly visible from any approach. While I was working, a car pulled up. A woman in her 60s got out, someone I didn't recognize. "Are you Marcus Abbott?" she asked. "I am, and you are, Helen Morris. I live in Maplewood Hills." I wanted to apologize for what the HOA did. Not everyone agreed with this warming hut project, and nobody knew Brenda was building it on private land. I appreciate that. She told everyone at the meeting that it was HOA common land, showed us the same map she showed you. A lot of us voted yes because we thought it was legitimate. Did anyone question where the land actually was? Helen shook her head. Brenda is very good at steamrolling objections. She's been HOA president for 6 years, and she runs the board like her personal kingdom. If you oppose her, suddenly you're getting violation notices for having your trash cans visible from the street or your grass being a 1/4 inch too long. Sounds familiar? Look, I just wanted you to know that some of us think you're completely right to fight this. What she did was wrong. If there's anything I can do to help, let me know. She handed me a piece of paper with her phone number. After she left, I sat in my truck and thought about the situation. This wasn't just about a building on my land. This was about an HOA president who'd become so accustomed to power that she thought she could do whatever she wanted, regardless of property rights or the law. My lawyer's cease and desist letter arrived at the HOA office 3 days later. Patricia sent me a copy. It was beautifully written, laying out the clear evidence that Lot 201 was private property, documenting the illegal construction, and demanding that the HOA pay for demolition and restoration of the land to its original state. The amount demanded was $12,000, based on quotes Patricia had obtained from demolition contractors. The HOA's response came a week later. Their lawyer, a man named Richard Foster, sent a letter claiming that the HOA had maintained the land for years, that walking trails through the property established an easement, and that my purchase of the land didn't negate the community's historical use of the space. It was legal nonsense, and Patricia confirmed it. "They're grasping at straws," she said over the phone. "Walking trails don't create prescriptive easements in North Carolina unless they've been used openly and continuously for 20 years under a claim of right. You bought this land 3 years ago, and even before that, it was owned by the Richardson family, who never granted any easement. So what's next? We file suit. Trespass, demanding removal of the structure, compensation for the violation, and attorney's fees. It's a slam-dunk case, Marcus." They don't have a leg to stand on. While Patricia prepared the lawsuit, the county building inspector visited my property. I met him there to provide access. Inspector Rodriguez spent 40 minutes examining the warming hut, taking measurements and reviewing the lack of permits. "This is pretty clear-cut," he said, making notes on his tablet. "No permit, construction on what appears to be private property based on the records I reviewed, and the structure doesn't meet setback requirements even if it was on HOA land. What happens now?" "I issue a violation notice to whoever initiated the construction. According to the work order I was provided, that's the Maplewood Hills HOA. They'll have 30 days to either obtain proper permits, which won't happen since it's not their land, or remove the structure. If they don't comply, we can impose daily fines and eventually use county resources to remove it and bill them." "Can I remove it myself?" He looked at me carefully. "It's your land and it's an illegal structure. Technically, yes, but I document everything and make sure you're protected legally." "I have a lawyer." "Then talk to your lawyer first, but if I were in your position, I wouldn't want someone else's illegal building sitting on my property either." The violation notice from the county gave me an idea. I called Patricia. "Can I legally demolish the warming hut myself?" I asked. "Yes. It's your land and it's an illegal structure. You'd want to notify the HOA first, give them an opportunity to remove it themselves. If they refuse, you can do it and bill them for the costs." "How much notice do I need to give them, legally? Reasonable notice?" "I'd say 10 days is more than fair, especially since they've already been told it's illegal construction." Patricia drafted another letter. This one was simpler and more direct. It informed the HOA that they had 10 days to remove the warming hut from my property, or I would remove it myself and charge them for the demolition, trespass damages, and restoration costs. Total bill, $15,000. I had the letter delivered by certified mail, so there'd be proof of receipt. The 10 days passed with no response from the HOA. The warming hut sat on my property, a constant reminder of their overreach. I checked the site daily, and nobody attempted to remove it or even approach the structure. On the 11th day, I rented a small excavator and hired 2 guys from my contracting network who I trusted. We met at my forest property at 7 in the morning. "You're sure about this?" asked Tony, one of my former crew leads who now ran his own small operation. "Dead sure." I own the land they built without permission. I gave them notice. Time to clean up someone else's mess. We started by documenting the structure one final time with video and photos. Then we got to work. The warming hut came down surprisingly easily since it hadn't been fully completed. We pulled off the roofing, dismantled the framing, and broke up the foundation with the excavator. Every piece of material was loaded into a rented dumpster. We worked for 6 hours straight, and by early afternoon, the site was clear except for the concrete foundation chunks. "Want us to haul out the foundation pieces too?" Tony asked. "Everything. I want this land restored to exactly how it was before they started." We worked until evening. The excavator smoothed out the ground where the foundation had been, and we scattered native soil and leaves over the disturbed area. By the time we finished, you'd have to look carefully to know anything had been built there at all. I paid Tony and his partner their quoted rate of $3,000 for the day's work, plus another $2,000 for the excavator rental and dumpster fees. Add in Patricia's legal fees, which were running about $4,500 so far, and my documented costs were over $10,000. That evening, I prepared an invoice. I itemized everything: demolition costs, equipment rental, legal fees, restoration work, and my own time for dealing with the trespass calculated at my consulting rate of $150 per hour. The total came to $17,300. Patricia reviewed the invoice and approved it. "This is all reasonable and documented. Send it certified mail, return receipt requested. Give them 30 days to pay before we add it to the lawsuit." The response from the HOA was explosive. 3 days after they received the invoice, Brenda Overstreet showed up at my house. I watched through the window as she stormed up my driveway, her face red with anger. I opened the door before she could ring the bell. "You destroyed community property," she shouted before I could say anything. "I removed an illegal structure from my property," I replied calmly, "after giving you 10 days' notice to remove it yourself. That warming hut cost the HOA $28,000. You're going to pay for it." "No, I'm not. You built it on my land without permission. That makes it my property under North Carolina law, and I can dispose of it as I see fit. You're going to pay me $17,000 for the costs I incurred dealing with your trespass. I'll sue you for every penny. You can try, but you won't win. I have property deeds, witness statements, photographic evidence, county violation notices, and documented communications proving I told you repeatedly it was my land. Your lawyer already knows this, which is why his response letter was so weak." Brenda's hands were shaking. "You think you're so smart. You have no idea what you've done. The HOA controls your life, Mr. Abbott. Every single aspect of your residence is subject to our rules. I will make your life hell. If you retaliate against me for exercising my legal property rights, that's another lawsuit. Ask your lawyer about tortious interference and retaliatory practices. See what he says." She turned and walked back to her car without another word, but I knew this wasn't over. Sure enough, 2 weeks later, I received a violation notice from the HOA. My front lawn had excessive weed growth and needed to be addressed within 10 days, or I'd face a fine of $100 per day. I walked my lawn carefully. There were 3 dandelions. 3. I took photos and sent them to Patricia with the violation notice. "This is textbook retaliation," she said. "Keep the notice, document the state of your lawn, and let them fine you. We'll add it to the lawsuit and use it to show their pattern of behavior." The next violation notice came a week later. My house numbers were not sufficiently visible from the street. They'd been in the same place for 3 years without issue. Photos were taken and sent to Patricia. Then came a notice about my fence being in poor repair, even though I'd stained it 6 months earlier. Then one about my mailbox post needing paint. Then one about Christmas lights being up too late in the season, even though it was only January 10th and half my neighbors still had lights up. Each violation notice came with a $100 per day fine threat. The HOA was trying to bury me in petty violations to force me to back down on the property trespass issue. Patricia amended our lawsuit. The original complaint for trespass and compensation was expanded to include harassment, retaliatory practices, and abuse of HOA authority. We documented every violation notice with photos proving they were frivolous, and we demanded actual damages plus punitive damages for the HOA's conduct. The lawsuit was filed in Henderson County Superior Court on a Friday morning in late January. By Monday afternoon, I had a call from Richard Foster, the HOA's lawyer. "Mr. Abbott, I think we should talk about settling this matter," he said. "I'm listening." "The HOA is willing to pay $5,000 to resolve all issues and both parties walk away. That's not even half of my documented costs for dealing with the illegal construction. It's a fair offer considering the uncertainty of litigation." "There's no uncertainty. Your client built on my land without permission. That's trespass. Black and white." And then they retaliated against me with frivolous violation notices. I have everything documented. Litigation is expensive, Mr. Abbott. So is losing, especially when punitive damages are on the table. My lawyer estimates your client could be liable for $50,000 or more by the time this is over, plus legal fees. $5,000 is insulting. Foster was quiet for a moment. "What would it take to settle this?" "Full payment of my invoice, $17,300. Written admission that Lot 201 is my property, and the HOA has no claim to it. Vacation of all violation notices issued since the warming hut incident, and a written agreement that the HOA will not retaliate against me in the future." That's asking a lot. It's asking for what I'm legally entitled to and protection from further harassment. Take it to your client. The call ended. I didn't expect them to agree, but I wanted to establish that I wasn't going to be pushed around. Discovery in the lawsuit began in February. Patricia subpoenaed all HOA records related to the warming hut project, including board meeting minutes, financial records, and communications. What we found was worse than I'd expected. Brenda Overstreet had never actually verified ownership of the land before beginning the project. Another board member, a man named Paul, had questioned whether they had the right to build there, and Brenda had shut down the discussion, insisting she'd handled it, and that the land was definitely HOA property. There was no documentation of any actual title search or legal verification. Even more damning, the HOA had taken out a special assessment against all homeowners in the development to fund the warming hut. Every household had been charged $350. With about 90 homes in Maplewood Hills, that meant the HOA had collected over $30,000 for this project. Patricia was stunned when she reviewed the records. "Marcus, this is fraud." Brenda Overstreet collected money from homeowners for a project she had no legal authority to undertake. She never verified she had the right to build on that land. Can we use this? Absolutely. But this is bigger than our lawsuit now. The HOA members were defrauded. They paid for a project that couldn't legally happen. That's when I got a call from Helen Morris, the woman who'd apologized to me early on. "Mr. Abbott, there's something you need to know. A group of us have been reviewing the HOA finances, and we've found some irregularities. Would you be willing to meet with us?" I met with Helen and 4 other homeowners at a coffee shop in downtown Asheville the next morning. They brought documents. We started looking into the warming hut project after your lawsuit became known, Helen explained. What we found is concerning. Brenda has been running the HOA like her personal account. The warming hut isn't the first questionable project. Another homeowner, a retired accountant named George, spread out financial records. Look at this. Last year, the HOA paid $4,500 to a landscaping company owned by Brenda's husband for common area maintenance. But we don't have common areas beyond the entrance sign. There's nothing to maintain. And here, Helen pointed to another entry. $1,200 for a community planning consultant. We checked with the company. No services were ever provided. The check was cashed by a shell company that traces back to an account Brenda has access to. I looked through the records. Over the past 3 years, there appeared to be roughly $30,000 in questionable expenses. Have you reported this? I asked. We're not sure how, George admitted. We're just homeowners. We don't have legal standing to demand a formal audit. But I do, I said. I'm a plaintiff in a lawsuit against the HOA. I can ask for a complete financial audit as part of discovery. Patricia was very interested when I brought her the information. This changes everything. If Brenda Overstreet has been embezzling HOA funds, that's criminal. We need to be careful about how we proceed. What do you recommend? I'm going to expand our discovery requests to include all financial records for the past 5 years, and I think we need to have a conversation with the district attorney's office. We met with Assistant District Attorney William Chen 2 weeks later. Patricia presented the evidence we'd gathered, the questionable expenses, the warming hut project undertaken without proper authorization, the special assessment charged to homeowners for a fraudulent project. Chen reviewed everything carefully. This is enough to open an investigation. If even half of these expenses are fraudulent, we're talking about felony embezzlement. What happens now? I asked. I'll coordinate with the Henderson County Sheriff's Office. They'll conduct interviews, subpoena bank records, the full investigation. If there's criminal activity here, charges will be filed. The investigation began quietly. I didn't hear much for several weeks, but Patricia kept me updated on what she could learn. Detectives were interviewing current and former board members, reviewing years of financial records, and tracing payments. Meanwhile, our civil lawsuit proceeded. The HOA's lawyer tried to get the case dismissed, arguing that internal HOA disputes should be handled through the HOA's own grievance process. The judge wasn't having it. This isn't an internal HOA dispute, Judge Martinez said during the hearing on the motion to dismiss. This is a straightforward property trespass case. The plaintiff owns land, the defendant built on it without permission. That's not an HOA matter, that's a legal matter for this court. The motion was denied. Trial was set for May. In April, the criminal investigation reached a conclusion. Detective Sarah Morrison from the Henderson County Sheriff's Office called me to let me know that charges were being filed. We found evidence of embezzlement totaling approximately $42,000 over 4 years, she said. Mrs. Overstreet was using HOA funds for personal expenses, fake consulting contracts, and payments to companies owned by her family members. What kind of charges? Felony embezzlement, obtaining property by false pretenses, and filing false financial reports. She's being arrested this afternoon. That's good news. There's more. We're also charging her with criminal trespass for the warming hut situation. She knowingly ordered construction on property she didn't own, ignored your demands to stop, and then retaliated against you when you enforced your rights. That's criminal behavior. Brenda Overstreet was arrested at her home on April 15th. The local news covered it, though they didn't mention my name specifically, just referring to a property dispute that led to a larger investigation into HOA financial misconduct. Helen Morris called me that evening. Did you hear? I heard. The whole neighborhood is talking about it. People are angry, but mostly at Brenda. A lot of homeowners are realizing they've been taken advantage of for years. There's going to be a special meeting to elect a new board. Good. Some of us were wondering if you'd be willing to speak at the meeting. Tell your side of the story. Help people understand what really happened. I thought about it. Part of me wanted nothing more to do with Maplewood Hills HOA. But another part recognized that most of the homeowners were victims too. I'll come, I said. The special meeting was held in the community center on April 23rd. Nearly every homeowner in Maplewood Hills showed up. The room was packed, people standing along the walls. Helen Morris had taken over as interim president, and she ran the meeting with impressive efficiency. We've called this meeting to address the recent criminal charges against our former president and to discuss the future of our HOA, Helen began. But first, I think we need to hear from someone who tried to warn us there was a problem. Marcus Abbott has agreed to speak about what happened. I walked to the front of the room, feeling about 60 pairs of eyes on me. Most of you know me as the guy who tore down the warming hut, I started. What you might not know is that I tried repeatedly to tell the HOA that they were building on my private property. I showed deeds, I called in the sheriff. I gave multiple opportunities to fix the mistake. Instead of listening, Brenda Overstreet doubled down. She insisted the land was HOA property even though she'd never verified that. She completed the construction, then retaliated against me with bogus violation notices when I enforced my rights. I pulled out my phone and projected photos onto the community center screen. The warming hut under construction, the violation notices I'd received, the documented timeline of events. What I didn't know at the time was that Brenda had charged each of you $350 for this project. Money that paid for a building on land the HOA didn't own, that had to be demolished, and that never benefited anyone. That money is gone because she never did basic due diligence. The room was silent. The criminal investigation found a lot more than just the warming hut. But the warming hut is what exposed the pattern. If she'd listened when I first told her it was my land, this all could have been avoided. Instead, she chose to abuse her authority, and here we are. A man in his 40s raised his hand. Are you still suing the HOA? Yes. My property rights were violated, and I incurred significant costs dealing with the trespass. I'm entitled to compensation for that, so even more money out of our pockets. That's not on me. That's on Brenda Overstreet and a board that didn't provide proper oversight. I tried to resolve this quietly. The HOA chose confrontation. Helen stepped forward. For what it's worth, I've spoken with Mr. Abbott's lawyer. The amount he's seeking is documented and reasonable. And honestly, after what we've discovered about the financial mismanagement, we're lucky it's not worse. We'll likely recover some funds from Brenda's criminal restitution, which can offset the settlement. The meeting continued for another hour. A new board was nominated and elected, with Helen staying on as president. One of the first votes was to authorize settlement of my lawsuit for the full amount I'd requested, $17,300, plus the additional terms about acknowledging my property rights and preventing future retaliation. Patricia called me the next day. The HOA's new lawyer contacted me. They're agreeing to all our terms. They want this resolved. Good. They're also going to pay our legal fees, which brings the total to about $23,000. That'll come out of their insurance. What about the criminal case? Brenda Overstreet is facing serious charges. Her lawyer is trying to negotiate a plea deal, but the DA's office is pushing for jail time given the amount of money involved and the pattern of behavior. The settlement was finalized in mid-May. The HOA paid me in full, acknowledged in writing that Lot 201 was my property with no HOA claim, and agreed to a 3-year moratorium on issuing any violation notices against my residents without approval from 3 board members. Brenda Overstreet's criminal case concluded in July. She pled guilty to felony embezzlement and criminal trespass. The judge sentenced her to 18 months in county jail, followed by 3 years of supervised probation. She was also ordered to pay full restitution to the HOA, $42,000, though her lawyer argued she didn't have the assets to cover it. Her husband filed for divorce 2 weeks after sentencing. I attended the sentencing hearing. I wanted to see the conclusion of this mess. When the judge asked if I wanted to make a victim impact statement, I stood up. Your Honor, Mrs. Overstreet's actions weren't just about money, they were about power. She believed that being HOA president gave her the right to do whatever she wanted, to ignore property rights, to retaliate against people who challenged her. The warming hut was just the most visible symptom of a larger problem. I hope this sentence sends a message that HOA board members aren't above the law and that property rights matter even when they are inconvenient. The judge nodded. Thank you, Mr. Abbott. I agree completely. After the hearing, several people from Maplewood Hills approached me. George, the retired accountant, shook my hand. Thank you for not backing down, he said. A lot of people would have just let it go to avoid the hassle. It was never about the hassle, it was about what was right. Helen Morris gave me a hug. The new board is working to rebuild trust. We've implemented financial oversight procedures, multiple approval requirements for large expenses, and mandatory title verification for any property-related projects. What Brenda did can't happen again. That's good to hear. You're still planning to stay in Maplewood Hills. My house is there. I like my neighbors. The HOA isn't the problem anymore, Brenda was. Life returned to normal over the following months. I continued my contracting business, the HOA left me alone, and my forest property remained undisturbed. I even worked with the new board to officially establish a walking trail easement through my land, properly documented and recorded, so people could enjoy the woods without any legal ambiguity. One afternoon in September, I was walking that trail when I encountered a family with 2 young kids. The father recognized me. You're Marcus Abbott, right? That's me. I wanted to thank you. We moved to Maplewood Hills right before everything came out about Brenda. We'd been looking at the warming hut project as a selling point, this great community feature. Then we found out it was all a lie. If you hadn't pushed back, who knows how much longer the fraud would have continued. I just defended my property. You did more than that. You held people accountable. After they continued on their walk, I stood in the clearing where the warming hut had briefly existed. The forest had already reclaimed the space. New growth covered the disturbed soil. In another year, you wouldn't be able to tell anything had ever been built there. That's how it should be, I thought. The land had been here long before HOAs and property disputes, and it would be here long after. What mattered was respecting that, respecting boundaries and rights and the basic rules that let communities function. I got a letter in October from the North Carolina HOA Reform Coalition, a group that advocated for homeowner rights and HOA accountability. They'd heard about my case and wanted permission to use it as an example in their legislative advocacy work. Cases like yours demonstrate why we need stronger oversight of HOAs, the letter read. Too many boards operate with minimal accountability, and homeowners have limited recourse when things go wrong. Your willingness to fight back and the criminal consequences that resulted show that reform is possible. I gave them permission. If my experience could help prevent similar situations for other homeowners, that seemed worthwhile. The final piece of closure came in November. The HOA had been working with their insurance company to recover funds from Brenda's actions. The insurance company paid out a significant claim, which helped offset the special assessment refunds the HOA was providing to homeowners for the warming hut project that never materialized. Each household received back their $350, minus a small administrative fee. Helen Morris told me that some homeowners had donated their refunds to a legal defense fund the HOA had established to help homeowners fight frivolous violation notices. It was a complete reversal from the old board's antagonistic approach. We're actually functioning like a real community organization now, Helen said, focusing on genuine maintenance and improvements, not power trips. That's how it should always have been. On a cold day in December, I stood on my forest property and thought about everything that had happened. A year ago, I'd watched a construction crew illegally building on my land and had to make a choice: let it go or fight back. Fighting back had been expensive, time-consuming, and frustrating. But it had been the right choice. Property rights meant something. The law meant something. Accountability meant something. And sometimes, enforcing those principles required standing up to people who'd forgotten that their authority had limits. I'd torn down an illegal warming hut and billed the HOA for trespassing. In the process, I'd exposed fraud, ended an abusive board president's reign, and helped reform an organization that had lost its way. Not a bad outcome for defending a few acres of forest land. As I walked back to my truck, I passed one of the trail markers the HOA and I had installed together. It showed the official easement boundary and included language acknowledging my ownership while welcoming community use of the path. Cooperation and respect instead of confrontation. That's all it ever needed to be. The civil settlement money went toward improvements on my actual house. A new deck, some landscaping, and a fence repair that was actually needed, not just cited in a bogus violation notice. The forest property stayed natural, a buffer of green space that the community could enjoy without anyone trying to claim ownership they didn't have. I ran into Brenda's ex-husband, Tom, at a hardware store in January. He looked tired but relieved. "I want you to know I had no idea what she was doing," he said. "The landscaping payments to my company, I thought those were legitimate contracts. I did some work on the entrance area. The audit confirmed you actually did work. You weren't involved in the fraud. Still, I'm sorry for everything that happened." She became obsessed with that HOA position. It consumed her. Power does that to some people. I'm selling the house and moving. Fresh start somewhere without an HOA. I understood the impulse, though I'd chosen to stay. Running away wouldn't have solved anything, and I'd worked too hard to let someone else's misconduct drive me out of a home and community I'd chosen. The legal bills were finally settled in February. Between the settlement, the insurance payout, and recovered funds from Brenda's restitution, I actually came out slightly ahead after all expenses. Not that it had ever been about making money, but it was satisfying to know that standing up for my rights hadn't left me financially worse off. Patricia called me in March with unexpected news. "You remember how we discussed whether the contractors who built the warming hut might have some liability?" "I remember. You said it probably wasn't worth pursuing." "Well, they reached out. They're willing to pay you $5,000 to settle any potential claims. They don't want the publicity of being associated with the case, and their lawyer thinks you could make an argument they should have done more due diligence before starting work." "That seems fair." They stopped as soon as I raised the issue. That's what I thought. I'll finalize the settlement. That money went into a college fund for my nephew, something good from something that had started so badly. The new HOA board invited me to their annual meeting in April as a guest speaker. I talked about property rights, the importance of verification and due diligence, and the need for HOAs to remember they existed to serve homeowners, not control them. An HOA should make living in a community better, not worse, I told the assembled homeowners. When board members start thinking of themselves as rulers instead of volunteers, problems follow. What happened with the warming hut was an extreme example, but the mindset behind it is common. Stay engaged, ask questions, demand accountability. Your board works for you. The response was strongly positive. Several people told me they'd been afraid of their HOA for years and were relieved to see the culture changing. In May, I got a letter from Brenda. She was 6 months into her jail sentence and had apparently been doing a lot of thinking. The letter was surprisingly honest. She acknowledged that she'd let the power go to her head, that she'd stopped listening to anyone who disagreed with her, and that she'd convinced herself the rules didn't apply to her because she was working for the community's benefit. She apologized for the trespass, the retaliation, and the damage she'd caused to the HOA and its members. "I made your life difficult because you challenged me," she wrote. "I couldn't accept that I might be wrong. That pride cost me everything. I'm sorry." I read the letter twice and filed it away. I didn't respond. Some apologies don't require acceptance or rejection, just acknowledgement. She was facing the consequences of her actions and I'd moved on. Summer came, and my forest property was beautiful. The trail I'd formalized got regular use from families walking dogs, bird watchers, and people who just wanted some quiet time in nature. I saw them from the road sometimes and felt good about how things had turned out. The land was being enjoyed by the community, just not in the way Brenda had envisioned. No building, no structure, no attempt to impose human will on the space. Just a path through the trees and the understanding that nature was the primary tenant here. I ran into Deputy Williams at a gas station in July. He remembered the case immediately. "That situation turned into quite the thing," he said. "We use it in training now, examples of how property disputes can uncover larger crimes. Glad it's educational. You did everything right." Documented evidence, clear communication, followed proper legal channels, made our job easy. "I had good help," he nodded. "That lawyer of yours is sharp and patient. Some people would have pushed for more aggressive action sooner. Patricia knew when to push and when to wait." Made all the difference. As the first anniversary of tearing down the warming hut approached, I reflected on everything that had happened. One illegal building had exposed years of fraud. One person's refusal to back down had reformed an entire organization. One property dispute had resulted in criminal charges, civil penalties, and systematic change. None of it had been my goal. I just wanted to protect my land. But sometimes defending simple principles has bigger consequences. The forest property was exactly what I'd wanted when I bought it years ago. A quiet piece of land where I could walk, think, and enjoy nature. The fact that it had become the center of a legal and criminal battle was never part of the plan. But I dealt with it, and the land remained mine, undisturbed and peaceful. That was victory enough. On the exact anniversary of the demolition, I walked out to the former warming hut site with a beer and sat on a fallen log. The forest was thick with summer growth, birds calling in the canopy, a light breeze rustling the leaves. No trace remained of the structure that had briefly stood here. I thought about Brenda in jail, Tom starting over in a new city, Helen leading a reformed HOA board, and the dozens of homeowners who'd gotten their money back and learned to be more engaged with their community governance. One action, rippling outward, changing lives. My phone buzzed. A text from Helen. "Community meeting tonight, wanna come?" I thought about declining. I'd done my part, said my piece, moved on. But being part of a community meant staying engaged even when the crisis was over. "I'll be there," I texted back, because that was the real lesson from all of this. HOAs worked when people paid attention, asked questions, and held leaders accountable. They failed when residents checked out and let small-minded people accumulate unchecked power. I finished my beer, tossed the can in my recycling bag, and walked back through the forest to my truck. The trail was well worn now, clearly marking the easement I'd granted. People respected the boundaries because those boundaries were clear and fairly established, just like everything else in life. Clear rules, honest communication, mutual respect. When those broke down, problems followed. When they held, communities thrived. The community meeting that night was routine business. Budget discussions, landscaping plans, scheduling for parking lot repairs. Normal stuff handled by reasonable people. Helen ran it efficiently, with input from other board members and questions from homeowners. No drama, no power plays, no attempts to override property rights or silence dissent. Just a functional HOA doing its job. That's what victory looked like. Driving home afterward, I passed the entrance to my forest property. In the moonlight, the trees were silvered shadows, mysterious and quiet. My land. Protected, preserved, and shared in a way that respected both ownership and community. I'd torn down an illegal warming hut, exposed a fraud, and reformed an organization. Not bad for a guy who'd just been trying to enjoy some peace and quiet in the woods. The next morning, I woke to find a message from Patricia. "Final legal matter closed. All settlements paid, all documents filed. Your case is officially over. Thanks for the business and congrats on seeing it through." I sat at my kitchen table, coffee in hand, looking out at the view I'd defended. My house, my land, my rights. All intact because I'd been willing to fight for them. Sometimes that's what it took. Standing up to bullies, whether they wielded HOA authority or any other kind of power. Following the law even when it was difficult. Demanding accountability even when it was inconvenient. The warming hut was gone. Brenda was in jail. The HOA was reformed. My property remained mine. Justice, delivered slowly but surely. I spent the rest of that day working in my garage, building a bench for my front porch. Simple work, creating something useful with my hands. After months of legal battles and criminal investigations, it felt good to just build something without worrying about property lines or permits or fraud. The bench turned out well. Solid oak, clean lines, large enough for 2 people. I set it on the porch that evening and sat watching the sunset, the mountains purple in the distance. A neighbor walked by walking her dog. "Nice bench, thanks. Built it today." "You're the one who had all that trouble with the HOA, right?" That was me. "My husband and I are glad you fought back. Things are better now." After she continued on, I sat in the gathering dusk and thought about those words. Things are better now. Not perfect, not without problems, but better. That was worth fighting for. The story of the warming hut became local legend in Maplewood Hills. New residents heard about it. Longtime homeowners told their version of events, and the lessons learned shaped how the community operated. The reformed HOA was more transparent, more careful, and more respectful of homeowner rights. All because one person had watched a construction crew building on his land and decided to do something about it. I demolished an illegal structure and billed them for trespassing. In the process, I'd reminded everyone that property rights mattered, that authority had limits, and that accountability wasn't optional. The forest remained peaceful and protected. The community functioned better. Justice was served. And I got to keep my quiet piece of land where I could walk among the trees and remember that sometimes doing the right thing required being willing to stand alone until others joined you, which they eventually did. That was the real ending to the story. Not just my victory, but a community waking up and choosing to do better. Choosing accountability over convenience, transparency over secrecy, respect over control. An HOA reformed because its abuses had finally gone too far. A neighborhood improved because one person refused to back down. A forest preserved because property rights still meant something. That warming hut had been torn down more than a year ago, but its impact continued. Every HOA meeting where homeowners asked tough questions, every board decision made with proper oversight, every respect shown for property boundaries was part of its legacy. I'd fought for my land and ended up helping reform a community. Not the outcome I'd expected when I first saw that construction crew, but a good one nonetheless. The bench on my porch became my favorite spot that summer. I'd sit there in the evenings, sometimes alone, sometimes with friends, watching the world go by. Every time I sat down, I remembered the battle I'd fought and won, not with violence or aggression, but with documentation, persistence, and faith in the legal system. Sometimes the system worked exactly as it should. My forest property remained my sanctuary. The walking trail saw steady use, properly authorized and clearly marked. People enjoyed the woods without anyone trying to claim ownership they didn't have. That was how community land sharing should work. Voluntary, respectful, properly documented. Not imposed by an overreaching HOA president who thought her position gave her the right to do whatever she wanted. Brenda was released from jail after serving 14 months with time off for good behavior. I heard through the neighborhood grapevine that she moved to Florida to live with her sister. A fresh start far from the community she damaged. I bore her no ill will. She'd faced consequences, paid restitution, and served her time. Whatever bitterness or anger I'd felt during the fight was long gone. She was just a cautionary tale now, a reminder of what happened when power went unchecked. The reformed HOA thrived. Helen served 2 years as president before stepping down, satisfied that new leadership was ready and that proper systems were in place. The HOA operated with multiple oversight procedures, financial transparency, and respect for homeowner rights. Everything Brenda's board had lacked. My contracting business continued to grow. The publicity from the case, ironically, brought me new clients. People who wanted someone who stood up for what was right, who understood property law, and who wasn't afraid to push back against overreach. I hired 3 new employees and started taking on larger commercial projects. Success, built on a foundation of principle. 2 years after tearing down the warming hut, I was contacted by a documentary filmmaker working on a project about HOA abuses. She wanted to interview me about my experience. "Your case is unique because it ended with criminal charges," she explained. "Most HOA disputes settle civilly or just fade away. Yours went all the way." "I had good documentation and a clear case," I said. "Plus Brenda's other crimes came to light during the investigation." "Would you be willing to participate?" I thought about it. Part of me wanted to leave it all in the past, but another part recognized the educational value. "Yes," I said, "if it helps other homeowners stand up for their rights." The interview was filmed on my forest property, naturally. The director wanted footage of the site where the warming hut had stood. I walked her through the timeline, showed her photos from my documentation, explained the legal process. "What advice would you give to homeowners facing HOA overreach?" she asked. "Document everything. Know your rights. Don't back down when you're clearly in the right. And remember that HOA boards are just volunteers, not rulers. They have authority only within proper boundaries." The documentary aired on a streaming service 8 months later. I watched it once. The filmmaker had done good work, interviewing multiple homeowners from different communities who'd faced various HOA issues. My segment was about 10 minutes of the 90-minute film. It generated a surprising amount of response. I received emails from homeowners across the country thanking me for fighting back, asking advice on their own situations, and sharing their HOA horror stories. I answered what I could, always with the same basic message: know your rights, document everything, and don't be afraid to fight for what's legally yours. 3 years after the warming hut incident, life had fully returned to normal. The case was distant history, mentioned occasionally but no longer the defining event of my existence. I was just a guy living in Asheville, running a contracting business, enjoying my forest property, and participating in a functional HOA that respected boundaries. The bench on my porch showed wear from use. The trail through my forest was well established. The community had moved on, but the lessons remained. Property rights mattered. Accountability mattered. Standing up to abuse mattered. I'd torn down an illegal warming hut and built an HOA for trespassing. In doing so, I'd protected my land, exposed corruption, reformed an organization, and reminded everyone that authority without accountability was tyranny, no matter how small the kingdom. The warming hut was gone, demolished and forgotten except as a cautionary tale. The forest remained, peaceful and protected, serving the community in the way nature served best, by simply being itself. And I remained its owner, guardian, and occasional visitor, walking trails through my own land and remembering the battle I'd fought to keep it that way. That was enough. That was everything.